Thank you to those in attendance, both locally and online. Super excited. And we're going to do a mock sanction hearing today. But the one thing you're not going to hear during this entire session is AI. We wanted to pick topics that are still impacting litigants every day that are pretty standard issues that we encounter. We thought we'd kind of go back to the basics. So I thought because people are taking different roles, they're taking different positions, and of course we have our honorable judge here, I wanted to make sure we had this disclaimer. I don't need to read it, we've all heard it 1,000 times, but these are exactly what we're doing. It's just our views, we're playing a little bit of a role and having a little bit of fun. So agenda, we're gonna talk a little bit about the panel, give you a little bit of the case. This is all in the resources. We've got some polls near to the end of the question because we're also allowing our audience to be the judge. So not only are we having Judge Singh get the rule on these, but we're going to have an audience rule on these arguments as well. So let's have a little fun. What are you going to learn today? I'm going to skip a little bit of this, but preservation, preservation, preservation. Data sources have varying risks, and it's not just about the behavior, it's also just missing the data. So let's introduce our panel. So I'm going to go left to right. Ashley, why don't you start?
Good afternoon. My name is Ashley Pickard-Dubin. I'm counsel at Day Pitney, leading our discovery practice, which is not an e-discovery practice. It's the full scope of discovery, soup to nuts.
All right, good afternoon. I'm Roxana Singh, a United States Magistrate Judge in the District of New Jersey.
Hi, good afternoon. My name is Kelly McNabb. I'm the partner in charge of ESI at Leaf Cabraser, Hyman & Bernstein. We do plaintiffs' side work only, and I work in mass tort product liability litigation.
Hi, everyone. Kristen Traylor. I'm the Senior Director of AI Transformation and Law Firm Strategy at Relativity.
For those who don't know me, I'm Scott Milner. I'm a partner and our global practice group leader of our eData practice. I'm playing the role of bailiff today. Thanks for that fun AI. You'll see a lot of AI graphics throughout these slides. All right, so what is our case? Who doesn't love a good cyber incident these days? We've got a case here, again, Cyber Trust Financial Services, national online lending platform. January 2025, CyberTrust suffered a major data breach exposing personal and financial information of over 10 million customers, including socials, loan histories, and payment data. A group of consumers led by plaintiff Jane Doe, a small business owner, a boutique Florida Gator clothing store, and a proposed class representative filed a putative class action alleging negligence, invasion of privacy, violations of consumer protection statutes. The case quickly became complex due to preservation failures on both sides. And we're going to go cross motions under 37E. Let's look at the chronology of events. One of my favorite things about Gen AI is no matter how many times you prompt it, it still gets it wrong. I'm gonna have a job forever. I don't think every one of my panelists during our prep called out that we have March 10th when Mr. Chumpers left the company, and March 14th, the real date is March 10th. And you'll notice that we interjected some fun throughout with some of the names like Mr. Chompers. So again, we had the incident. We had the breach notification on February 10th, 2025. On March 2nd, we had Jane Doe retaining counsel and discussed bringing the action. March 10th, we had the Jane Doe's IT contractor, not inventator. Love when you get quotes and they still get it wrong. Left the company and actually left his laptop get wiped and sold. March 14th, we actually filed the complaint. Plaintiffs then sent a legal hold on March 30th. Then we get to April 15th, CyberTrust issues internal legal hold, but delays the hold notice to their third-party cloud server vendor. CyberTrust fails to suspend Slack's 90-day retention period April 30th. May to July, we've got Telegram message among named plaintiffs deleted under their auto-deletion. August 2025, plaintiffs moved to sanctions. CyberTrust files a cross motion, and we're here today, February 2024. 2026. I don't know my days anymore. I've been losing. So, Your Honor, turning the floor over to you.
Thank you, bailiff. Next time, please know the date. Good afternoon. We are here in the matter of Jane Doe versus CyberTrust Financial Services. We have before the court 2 pending motions for sanctions. I'll begin first with plaintiff's motion for sanctions.
Yes, good morning, or good afternoon, Your Honor. Kelly McNabb on behalf of plaintiff Jane Doe. This is a very serious spoliation issue we have here. CyberTrust did not preserve and lost Slack data. The parties agree on one thing in this motion, relevant to this motion, is that the Slack communication should have been preserved. They did not do so. And when they did not do so, the 90-day retention period that they had set continued to run. And as a result, they lost key channels relevant to the incident response to the data breach. So,
Counsel, may I interrupt and ask you a question?
Yes, please.
Did you happen to discover anything in the discovery that you have received to date that Slack communications have been used by the employees?
Yes, indeed, Your Honor. And in fact, we have an email where someone is warning that they may lose Slack threads if they don't change the settings soon. We know that they had channels that were titled incident-response, vendor-security, and those were purged. So we have evidence not only that data was lost, but that it could not be reproduced. Why would an employee be cautioning or warning about deleting the Slack if it was duplicative of what would be found in email? And this email also shows intent, which is required under Rule 37E2.
Thank you, counsel. And I am concerned here from CyberTrust's perspective, what's going on with these Slack messages?
Your Honor, Ashley Picker-Dubin for CyberTrust. Yes, we do agree that there should have been a preservation in place, that the parties do agree that this is data that should have been preserved. That said, it was not an intentional deprivation of this particular piece of evidence. This is data that through a technical implementation was not preserved. The hold notice was sent out, and the primary information was retained at that time, which was the email communications. And the custodians that we spoke to, that was the information they gave us and said, this is the pertinent information. At no point until we had sought additional clarity in reviewing the emails suggesting that there had been a Slack channel, did anyone mention that the Slack channels were important or were used in a manner or capacity that would indicate that they had unique data to them.
Counsel, though, do you concede that the Slack messages may not be entirely duplicative of what's within the emails that have been produced?
I cannot say with any level of certainty because they were destroyed before, as part of the ordinary course, with the 90-day retention that's set by the company's IT team. But the information as it was provided by my client is that the materials themselves are not particularly relevant and certainly no more so than what is in the emails. And the plaintiffs are more than welcome to depose any of the witnesses on what might have been on the Slack channels.
So then is it also your position then, if I'm understanding you correctly, that there is also no prejudice to the plaintiffs under E1? Should the court look at that subsection?
Absolutely. There is no prejudice here and certainly no intent. This was an unintentional mere technicality, and the failure between IT and legal was certainly not meant to deprive plaintiffs of evidence.
Well, this is a very tech-heavy issue. I do want to turn it over to our neutral expert who's appeared today. Thank you for your assistance today. Can you tell us a little bit more about Slack and the retention policies and how it may be modified or adjusted in any way?
Yes, Your Honor, thank you. So CyberTrust was actually on the Business Plus plan of Slack, which out of the box is indefinite retention, but because they were following their own retention policy, they set it to 90 days. But they could have just as easily changed it when they found out they had this litigation. I did take another look at it to see, is there anything else we can do here? If they were on the enterprise plan, which is the plan up, we might have been able to find some tombstones to give us an idea of how many messages were lost, but that's probably not likely because of the plan that they're on. And then, unfortunately, the actual channels are deleted. Like those are gone. We're not going to be able to retain them. We're not going to be able to get them back. We're not going to be able to figure out how many messages were lost.
So what has been gone is completely gone and cannot be retrieved even with some sort of forensic analysis?
It's very unlikely that we're going to find anything, yes.
Is there a way to find the volume that has been lost?
Like I said, I looked at their settings, and because of the way they had it set up, we're still not going to even be able to figure out the volume. And that would have only been the volume on specific messages to each other, not from these channels. Once these channels are deleted, they're gone because of the way their system was set up.
Okay, and you can set the retention policies as the operator of the Slack platform.
That would have been simple for them to do, yes.
Okay, thank you, appreciate that. Great. Now, I understand we have additional issues going on. Let's.
Objection, Your Honor. Speculation.
Are you speaking on behalf of CyberTrust?
I'm just the bailiff.
Oh, okay. Thank you, bailiff. So I understand there's additional issues with CyberTrust, though. I'm interested to hear what more is going on.
Yes, Your Honor. We do unfortunately have another incident of lost data. So not only did CyberTrust not change the retention policy of Slack, which would have been very simple for them to do, according to my expert, that I diligently hired and brought into the court to support my motion. Okay, anyway, so the third party lost data. CyberTrust uses a third-party vendor called CloudServe to host their data. What should have been done is the minute that they knew about the breach, they should have put their vendor on notice. That would have been standard of practice, but they did not do that. They don't get to discharge their preservation obligations because their data is sitting with a third party. That third party is under their control because they have a contract with that third party, and they, under the legal rights standard, which is applicable in every single circuit except for the second, they could have sent the third party, CloudServe, a letter, a litigation hold that said, preserve our data. We know that CloudServe would have then preserved that data. They would have suspended their auto delete and these server access logs, which would have shown who accessed the data, how was it accessed, when was it accessed, which is central to the breach, to the causation issue of the breach. Those would have been preserved. So plaintiffs have met their burden, particularly under, if not 37E2 to show intent, certainly under 37E1 to have a sanctions order here.
So you are seeking relief under E1 as opposed to E2?
I am under this motion, yes, it is E1.
And so you argue that the information and data stored by CloudServe is within the possession, custody, or control, preferably here the control seems to be your argument, of CyberTrust. However, you mentioned that the retention policies are held and responsible in part by what CloudServe is doing, not CyberTrust. So can we know for certain that there is actual control if CloudServe could have opted to ignore the legal hold notice if CyberTrust had served it timely?
So what my understanding is from the third-party discovery that we conducted on CloudServe is that they would have followed what CyberTrust requested. So they would have suspended that auto delete.
And you did obtain that discovery from CloudServe directly?
Yes, we did.
Thank you. And what do you have to say in response, counsel?
Well, that's very interesting because the plaintiffs never provided that third-party discovery to the defendants.
Motion to compel coming.
We have potentially additional motions to bring.
Understood.
Here, we're not saying that there isn't this potential of control. That said, we are not in control of their retention policies, and CloudServe is not just CyberTrust's vendor. They are a company in and of themselves, and these logs are not unique to CyberTrust business. What we can provide and did provide are the forensic logs for the investigation itself, the cyber incidents response materials, internal communications, the communications with CloudServe, and documentations into the investigation. So the prejudice in not having the original logs is minimal at best, and the materials from the original investigation into the incidents response were provided along with the forensic analysis performed at the time.
But wouldn't the logs be critical to the issues at the crux of this matter when we're talking about a cyber attack involving the information stored on CloudServe?
But the original incidents response forensic work analyzed those logs at the time.
So there's sufficient information that would recoup the same information
Correct.
Otherwise lost. Okay. And did your client happen to know what the retention policies were by CloudServe?
They were not aware of them at the time, but once the issue was identified, ultimately a preservation notice was sent to CloudServe, by which point it had already gone past the 60-day retention that is typical for their company.
Okay. And I'd like to turn to our expert again. And can you tell us a little bit more about the import and what kind of information may be in the logs that are no longer there in CloudServe?
Yeah, the logs are really critical during a data breach because they're going to tell you what was queried, what was lost. And so the fact that we don't have those logs anymore is a problem. I think there are some other things we can do in this case. We can look at some of the other systems like the firewalls, the routers, the switches, all kinds of other information. So there may be a backup that will show us what was in those. We can do a forensic analysis and hopefully find some more information about kind of what was lost and what was on those logs. Another aspect is we could also look at some of the communications of CloudServe themselves, because they may have had information in their emails and their Slacks and other communications, which would give us some more insight into this.
So really additional information from CloudServe would help us understand kind of the volume of what is lost, what can be recoverable, and what cannot be recoverable. Is that right?
That's correct. We'll need to do a forensic analysis of some of these other things, but yes.
And it is your view, though, that the logs would have unique information separate and apart from what the defendants have already produced?
I mean, it is possible, yes. And we can we don't have those to analyze at this point, but.
Okay. Sounds like some additional discovery may be necessary. All right, well, I understand your hands are not clean either on the plaintiff side. Defendants, you're bringing a cross motion as well. I'll turn it over. What do we have here?
Your Honor, this particular failure is egregious. The plaintiff's head of IT departed, so Mr. Chomper's laptop was wiped and sold rather than being preserved at a time when the plaintiffs were uniquely in a position to know that they anticipated litigation, which, based on the timeline that we laid out at the very start of this hearing, Mr. Chompers left 4 days before the plaintiffs filed suit. By then, they had engaged counsel, presumably had a pretty well-organized complaint, and yet still allowed the data to be entirely wiped. They claim—
Well, it is true that Mr. Chompers left before the complaint was filed. Isn't that right?
That's right, but certainly they had engaged counsel and were about to file suit. So it was reasonably anticipated, and the preservation should have taken place at that time. In particular, because they can't— the plaintiffs, though they claim we're not under an obligation to preserve, did reasonably or should have reasonably anticipated litigation based on the fact that they filed 4 days later. And there was obvious discussion about a class action based, again, on timing alone. But this isn't an accidental loss. This was a purposeful wiping of a laptop. This was purposeful selling of a laptop. So even if the laptop could have been recovered, it was then moved completely out of their control.
Do you argue then that purposeful conduct is enough to find intent under 37E2?
Absolutely. And the plaintiffs claim that all of the data that was on that laptop was synced, but yet the local configuration files, scripts and tools, cached metadata, administrative access artifacts, backup client settings, and records of what security settings were in place for warnings and remediation steps were taken, put us in a position to be unable to defend our case as to whether there was potential for comparative fault.
So you found through discovery thus far that this likely is not duplicative information that would have been stored on Mr. Chomper's laptop?
That's correct.
Okay, very interesting. All right, what do plaintiff have to say for himself?
Your Honor, we completely disagree with the characterization of the factual record here. The information that was, quote, lost absolutely is duplicative of what was preserved. So first of all, the threshold requirement under 37E, whether you're looking at E1 or E2, is that the data was lost and cannot be restored or replaced. The laptop contained synced communications and metadata, meaning it was synced. So defendant cannot show even the threshold requirement here. That should be the end of the discussion. But even if the data wasn't duplicative, when Chompers left the company, plaintiffs weren't under an obligation to preserve the evidence because we hadn't filed suit yet. And I understand that defense counsel has represented that plaintiff knew that they were going to file suit, but that is just simply not the case. I know it may have been 4 days later, but we are a very good law firm here, and we can put put complaints together very fast.
Very expeditious.
Furthermore,
I'd like to see that fee application at the end.
Objection based on the timeline already identified. They'd already engaged counsel.
Sustained.
okay, so in any event, my third point is we're not sophisticated. My plaintiff is not a sophisticated party, and there's no bad faith here, and just please take pity on us.
Does pity weigh into the equation under 37E2 for intent?
Well, I think it should. It goes to no bad faith.
Fair enough. And from the expert's perspective, what could we do when we've lost a laptop like this?
You know, Your Honor, I can work miracles if I had that laptop, right? I get paid a lot of money to find things. I can't do anything. They no longer have the laptop. So the only thing I could suggest is that sometimes those local files, people think they're saved locally, but they're actually maybe being backed up to OneDrive or something like that. So we might be able to look at the policies of the organization and see, possibly, but that's a long shot. Because what's on that computer is gone because I can't get access to the computer.
Would you be able to go into plaintiff's cloud serve documents, whatever it's a share drive or OneNote, whatever it might be, and be able to tell which documents may have been originally sourced from that laptop?
I would only be able to know if the policy actually had it syncing there. So otherwise, no, I won't be able to. If it's only saved locally, it's gone.
Okay, good to know. Thank you.
And Your Honor, I don't think we had this in the fine print. It was actually in clear print. But plaintiffs submitted a privilege with claiming work product in those 6 days before they filed a complaint. Just making sure I had to get that on record.
That is a helpful point.
I have no response.
Back to pity.
Are you claiming privilege? Privilege over that material? And I understand we have additional issues regarding communications amongst named plaintiffs.
And an even more egregious piece of intentional spoliation, the named plaintiffs had a Telegram group chat set with a 30-day retention to auto-delete their messages, where they, quote, there's in data produced to us, quote, as we agreed on Telegram, we'll delete this once we're done talking to counsel. This is not personal venting as the plaintiffs may tell you it is. This is a clear intention to deprive the defendants of relevant communications, and despite their joint prosecution agreement, there is no privilege between these individuals. This is not work product. They're not doing this at the direction of counsel, or if they are, I have further sanctions motions to bring. But this is being performed and discussions between these named plaintiffs without the benefit of the protection of privilege. This wasn't a group chat that contained counsel. It wasn't at the direction of counsel. They chose to do this through an encrypted platform where they would intentionally delete the messages, and it was very specifically about this litigation.
And I think you indicated in your motion papers that the majority of these lost communications were actually from before these named plaintiffs decided to become named plaintiffs. Is that right?
That's correct.
And does that make a difference in your argument in terms of equation if it was before or after they made that decision?
It does not. Okay. So there's no privilege. There's no privilege communication during the course of these communications. Certainly before they became named plaintiffs, there was no privilege. But even after they became named plaintiffs and once there was a joint prosecution agreement in place, they're still not chatting in a very casual way about the litigation during the course of a group chat.
And since they haven't yet decided to become named plaintiffs, do they still have an obligation to preserve?
Absolutely, because at that point they were reasonably anticipating litigation. If nothing else, they had reasonable loss and were one of the named plaintiffs was participating in the chat. So if nothing else, she had an obligation to preserve. So the whole chat would have to be preserved.
Okay, very interesting. So counsel, why are the named plaintiffs communicating over Telegram?
Well, Your Honor, the reason why the plaintiffs were communicating over Telegram is because they were working together under a joint prosecution to bring the case. So my argument is that there was a joint prosecution agreement in place, and there was an agreement in place where the plaintiffs were discussing bringing the litigation. I believe that falls under the privilege. But even if it doesn't, what my clients tell me is that they did not have the ability to change the auto-delete function on Telegram. So they didn't have even the option to change that deletion. Moreover, the underlying facts contained in the Telegram messages can be obtained through discovery such as the depositions. So again, we're back to not meeting the threshold requirement under 37E that the information was destroyed or lost and cannot be reproduced. It can through deposition.
But with depositions, you're relying upon the memories of the individual named plaintiffs, and they may not necessarily recall the specific text messages or messages through Telegram. Isn't that right?
It may be right that not every single quote or message is recalled, but I think that there's enough there to say that the gist of what they were discussing on Telegram, to the extent it's not privileged, can be recreated in their depositions.
And you indicated that you're relying upon your client's representation about whether they could turn off the auto deletion. Have you done an independent investigation into what a user can do with Telegram?
Well, Your Honor, unfortunately, I was not aware that the preservation obligation first runs through counsel, so I did not do that until now. So now we will hear from the tech expert to realize what I should have figured out, and I admit this was my mistake, but I relied on my client to tell me what could or could not be preserved and how these systems worked. But we'll hear what the tech expert has to say, and I believe that our special master will be on my side on this issue.
And you did send out a whole notice to your individual clients, correct?
Indeed, I did.
Okay. Let's hear from the expert. What's going on with these Telegram messages?
Thank you, Your Honor. Yes, it's my understanding that Stacy Swamp, one of the named plaintiffs, set up a group on Telegram to communicate. As the administrator of that group chat on Telegram, she could have easily set the retention to whatever she wanted. So, in fact, she had to affirmatively set it to delete. And so, yeah, I'd have to say that that's kind of what happened there. And then there was also some individual messages back and forth, which weren't part of that group. Again, those could have been preserved. The only thing we have to be a little bit careful of is sometimes when it's set to retain, if somebody sends a message, they could send it as like auto disappearing, like one by one, but that's not my understanding of what happened here.
In your experience as an expert reviewing and pulling these types of chat messages, do they usually contain distinct information when you're chatting over messaging, such as Telegram or other devices, compared to what you put in emails or what you converse with verbally?
In my experience, this is where all the good stuff is. Yeah, that people are not putting what they put in Telegram in email, so it's going to be
distinct, I imagine.
Very distinct, yes.
We really do
That's
have
helpful.
the best expert in the industry.
All right. And just to be clear, the defendant is seeking sanctions under Rule 37E2 on this basis?
Yes.
Okay.
An adverse inference at best.
Adverse inference. Okay. Not default judgment or
Not
dismissal of claims?
Not at this time.
Okay. All right. And plaintiff's relief is seeking sanctions under both E2 and E1, as I understand it.
Correct, Your Honor.
Okay. Anything further?
Well, first I want to thank Judge Singh, Ashley, Kelly, and Kristen. There was a lot of prep that went into this. We actually really thought through real-world examples of what we're seeing on a daily basis, navigating individuals that now have all kinds of access to different applications, companies learning preservation issues through an iterative process, right? We don't always know who's handling what data may be relevant at each time. And they spend a lot of time trying to come up with real arguments that they would make, today if these were here, obviously taking a little spin on them overall. So we're going to move
Obviously, we would do a better job for our clients.
Well, but I'm saying we actually did have some fun time talking about the arguments. We're going to move into the ruling now. And just so you know, we're going to launch polls for those online and those in person. Love audience participation. So we'll go one by one with Judge Singh, and then hopefully Dean will be able to get the audience poll to see if they agree, disagree, or they're just clicking a button to get some credit. So Judge Singh, we're going to go to the first one.
Well, I just want to know, in the polling, is it anonymous, or will I know who disagrees with me?
It's anonymous.
I'm teasing. So the first issue presented on plaintiff's motion for sanctions in regards to the defendant's failure to turn off the auto deletion function of the Slack messages. The court does find that there has been the failure to reasonably preserve information and that there cannot be an adequate alternative source to discover that information. The court also finds that there has been the intent to deprive an adverse party, here the plaintiff, of that information by virtue virtue of the ability to quickly change the auto deletion function, the ease with which they could have fixed that, the fact that Slack automatically would preserve the information but for the setting of the auto deletion, and also CyberTrust's knowledge of the nature of this litigation, as well as the knowledge that their employees communicated through Slack regularly on issues, including those at issue in this case. Accordingly, the court does find that sanctions pursuant to Rule 37E2 are appropriate. The court will permit an adverse inference to be presented to the jury at trial.
Whew. All right. Wasn't expecting that. What do we got in the audience?
Defense counsel over here.
10% for no sanctions. 70% under E1. 18 E2. 2% just audience participation. I like it. All right. So we've got a little bit of a disagreement, maybe the intent to deprive. And I think, while we're going through some of this, and we'll go open the next poll in a second, but I know we were debating whether we thought the license would make a difference. So obviously, Kristen explained that the default was unlimited retention.
Exactly.
If there were a lower license where they would have had to incur the cost for a more expensive license, does that change the dynamic in the decision?
I would think that weighs in on the intent issue. You would probably still find prejudice in that scenario, and then it would be an E1 sanction. But I think the intent here is because they had automatically set it under their particular business model for Slack as permitting these auto deletion functions, that it weighs in on the intent. They knew they did that. They made a conscious effort to have auto deletion. They knew there was this lawsuit. They didn't turn it off. There was 2 steps where they were knowingly involved with not preserving data that would be relevant to the litigation. So I think it's relevant to intent.
And for the audience purposes, we chose Business Plus specifically so that we couldn't try and go back and retrieve the data under Enterprise.
All right, let's, Your Honor, ruling on the third-party data loss.
All right, this is
the E1 request.
The E1 request. In regards to this, the court has considered whether the information housed and stored by CloudServe were truly within the possession, custody, or control of the defendant, CyberTrust here, with consideration of Rule 34. In this court, we do follow a legal right standard for possession, custody, or control. Here, the plaintiff proffered sufficient evidence that there is a contract between the parties, between CloudTrust and CloudServe, whereby CloudTrust could adequately seek that information, could order CloudServe to preserve that information, and CloudServe would in fact be obligated to preserve that information at the request of CyberTrust. Accordingly, the court does find that there has been a loss of information that would be relevant to material issues in dispute. The court also finds that the loss of that information, particularly going to the import of the logs as referenced by our kind expert here, would unduly prejudice the plaintiff by not having that information. Accordingly, the court will permit limited sanctions under Rule 37E1 in an effort to cure that prejudice, which may take the form in additional discovery from CloudServe as to what can be or cannot be retrieved from their databases.
For clarifying question, Your Honor, will CyberTrust be solely responsible for the expense of that additional discovery?
Granted.
All right, what do we got in the audience? 22% no sanctions. 65 for E1. 12% for E2. And 2 just playing along. I love it. Hope they're consistent. Awesome. Well, thank you.
I think I would be able to prove the intent part of E2, so I agree. I kind of put all my eggs in the one basket of
We convinced 12% of our audience, okay? So good job on that.
12%, that's pretty good. Maybe I shouldn't have put all my eggs in that application. Okay.
Well, it can't be only bad on the defense side.
All right, now we're turning to the defendant's motion. The first issue, again, being Mr. Chomper's laptop that had not only been wiped, but also sold after the plaintiff had retained an attorney, but yet 4 days before the filing of the lawsuit. Here, the court finds that there likely, or there likely was information on that laptop, considering the role of Mr. Chompers at plaintiff's business that would be relevant to this lawsuit, and potentially would have included information not otherwise stored at plaintiff's own databases that have been preserved and are produced to date. The court does find that the failure to preserve that information does prejudice the defendant in this instance, again, focusing on the role of Mr. Chompers as the IT individual. And while it is a small company, smaller companies often rely more heavily on their IT employees than they would necessarily otherwise at larger facilities, and therefore the loss of unique information, again, would be prejudicial to the defendant. Accordingly, the court finds that sanctions under Rule 37E1 are appropriate. I do not find that there was an intent to destroy this information. Rather, I do find, considering all the circumstances, at best this was negligent or gross negligence, which does not rise to the level of bad faith sufficient to establish intent under 37E2. I will permit sanctions in the form of additional discovery to the extent necessary, limitations of introduction of certain facts, et cetera, as requested by the defendants in their briefing, and then to the extent necessary, any additional remedial measures at the expense of plaintiff.
All right, what do we got in the audience? 15% no sanctions, 51 for E1, 33 for E2, and 2% still playing along. All right, consistency is key. All right.
There is no sympathy.
We have a question in the audience.
We have a question from the online audience that's also getting some thumbs up. So how should these auto deletion policies be addressed under information governance policies? Would a comprehensive policy addressing auto deletion on the defense have helped him in the intent issue?
And Judge, if you'll humor me, that was actually one of our questions for the discussion. So if we could finish the fourth hearing, we'll definitely tackle that first, because we actually talked for the 8-minute post-discussion part would be discussing good IG policies versus when to turn off auto deletion. So we'll get to that question for sure. All right, we're going to move right to the final announcement or ruling.
So the last issue is the plaintiff's failure to preserve these Telegram chat messages by the named plaintiffs while they were determining whether, in fact, to become named plaintiffs. Here, the court finds that there has been a destruction of relevant information. Parties and individuals often communicate and say different kinds of information through informal chat platforms such as Telegram, and with the understanding that the information would not be preserved, they might have been even more forthright. More importantly, because these individuals, now the named plaintiffs, were discussing amongst themselves whether to become named plaintiffs, it is more likely than not information could have been shared as to damages and or causation that would be relevant to the issues in dispute in this litigation. Although there is the ability to depose these plaintiffs, there again may be issues in the plaintiff's ability to remember the precise nature of these messages, of course, credibility concerns that the defendants would be unable to assess or test without the availability of the written real-time Telegram messages. Accordingly, the court finds that there has been a failure to preserve information that would be relevant in this suit. Not only is it prejudicial, I also find that because there is the indication that the parties discuss the deletion of the Telegram messages and had the easy capability through the administrator to turn off the auto deletion function, there is an intent to deprive the adverse party of this relevant information. Accordingly, the court awards sanctions under Rule 37E2 and will permit an adverse inference at trial.
Excellent, thank you. Dean? 13% for no sanctions.
Wow.
Sorry, which one? 49 for E1. 36 for E2. And the same 2%. Beautiful, beautiful. All right, we're going to turn into some discussion. I love the high five push. I did not know that was actually going to happen before this graphic was prepared. So why don't we dive right into the actual question that was from the online audience, getting a lot of attention. There sometimes does become a conflict of good data hygiene from an information governance perspective, and then changing the impact. And Judge, not to put you on the spot, but you kind of even teed that up of the fact that they bought this license which had indefinite retention capabilities. They purposely changed it to 9% for ordinary business purposes, but failed to stop that when the legal hole was there. how do we guide companies and organizations on, and this is good to anybody, but on the kind of conflict of get rid of the data when you don't need it. This is a cyber attack. This is a good example why you want to get rid of the data, but then knowing when you have to disable to make sure you preserve it. I don't know.
I mean, I'll just jump in real quick. From my perspective, I think if you're going to purchase a platform or a product that you're going to purposefully set the settings to auto deletion within a 90-day period or whatever, your corporate governance, you should have something in place in writing that all of your employees, your IT individuals know what will happen in the event we reasonably believe lawsuit is coming. It should be part of your overall corporate structure of preservation in the event of litigation and or other types of compliance issues that you may face, depending on the nature of the business, from my perspective. I think have it in writing and training about how to follow it.
And to add on to that, it's once the retention policies are set for the organization and there's a legal hold policy in place, companies need to ensure that the IT teams putting the implementation, actually implementing the hold, know what needs to be implemented. Serving a preservation notice is not sufficient. It actually has to be implemented. And if a company is using a tool like Slack and it has a 90-day retention and the custodians are being served with a preservation notice, that should have been an integral step in the process. Is what data sources are they using? Having an early custodian interview to understand, regardless of this substance, what relevant data sources are you using? And if there was an incident response channel, as there was here, that's certainly a relevant data source, making sure that hold is actually implemented. And that's it's such a huge part of the step. And that's where there's this sort of cross-channel and intersection of IT and legal, and why it's so important that legal and IT do work closely together.
And for those online, I think one of the practice pointers we've been implementing is actually sending IT a specific IT level hold to help guide them on the buttons to push. We work with a lot of clients ranging in sophistication, and there's a lot of clients that have a process. They understand where to look. They understand the buttons to push. But there's a lot of times we're working with people who are actually running an email or IT environment. They're not litigators, right? They're not dealing with this. They don't understand the nuances of what it means to do that. So we've been preparing specific instructions to those IT teams, and especially third-party IT teams who probably just following a contract with the SLAs that may not even understand what has to be pushed.
Which is great until they onboard a new tool that I told you about.
That's right. We have another question, Judge.
Another online question. Would there be a consideration for a sanction against the attorneys for not doing an appropriate preservation letter and stopping the auto-delete?
I think in my experience, judges are loath to do that. It really depends on the facts and circumstances. And from what I've observed, it has to be quite egregious where the attorneys have had a complete and utter failure of their responsibilities. More often than not, the cases that I've observed, it's usually on the part of the clients, assuming that there has been an adequate and robust legal hold in place.
I guess the Zubilake duties that started a long time ago now, 37E has taken over for that. So that's a change. But under Zubilake, it might have been a different story, I think.
What I've seen in some of the case law on this issue with counsel being sanctioned is it's not just repeated failure, but it's also a cover-up almost. And not, once the counsel becomes aware that there may have been something that was not preserved that should have been, it is best practice to take that on head on and figure out what happened, what's going on, what was not preserved, can that be reversed, can we get the data back, et cetera, and then making sure that you're meeting and conferring with opposing counsel on that to try and step in front of it instead of waiting for them to figure it out, because that's when you really see these horrific sanctions orders where I don't want to say cover up like, oh, it's some sort of conspiracy or something like that, but it's just coming out with it is usually a better course.
Well, and it's more about like the candor to the tribunal. You see it where the judge has ordered that the party do something. The attorney knows that the data is lost. They say nothing. It happens again. Yeah. They go before the judge multiple times. They assure the judge they're going to produce. There's motion practice, and then there is this failure. And at that point, the attorney is responsible, not just their client.
No, absolutely. The attorney themselves have taken some sort of step to not preserve in some way and to not be upfront and honest with the court. I actually have had an instance, not in the eDiscovery context, but where there was a destruction of evidence on behalf by the client. The attorney became aware of it and immediately notified adverse counsel in the court. And there, the appropriate sanction I found was for the party themselves and not for the attorney, because the attorney was very forthright with everything that had been going on and was upfront with what had happened.
And I actually really appreciated those arguments where neither counsel was trying to hide the fact that the data was gone, right? And I think so many times I've seen people be like, well, it could be so, like, no, we admit it's gone, and here's why, though. And there was no intent. There was, here's where we think we can try to identify the discovery in alternative forms. And I think that's the kind of the message there, is not trying to hide the ball. And Kelly, I want to stick with you for a second in the last couple of minutes, and then we'll keep going on through. You mentioned, obviously, on the plaintiff side, probably deal with a lot of individuals.
Yes.
In the old days, I joked when I started practicing, they had no data, right? It was all in the corporate environment. They left the company, it was gone. Now, ephemeral messaging, mobile devices, personal email, social media. What are some best practices or practice pointers you can tell the audience on people dealing with that, the individual side who may not have sophisticated IT, to help them navigate back-end preservation?
Sure, and this actually dovetails from the prior panel on mobile devices. So I do represent some smaller companies, school districts, et cetera. So I do have other, more sophisticated clients. I think preservation with individuals is much harder. And these days, I mean, in your phone, you have more data than anyone. And the issue with individuals is their personal information is just completely commingled in there. It's just totally overlapped. And a lot of these apps or message systems, you can't just segregate out personal from issues with the litigation. It's all there together. And it can be very challenging. What Suzanne said earlier, the prior panel, I can't remember exactly who it was who said it, the best steps is to do the collection, but sometimes that is incredibly expensive, particularly in like mass tort litigation, where you could have potentially thousands of plaintiffs. Is every single plaintiff going to do like a physical collection of their device? It would just be completely cost prohibitive to do that. The analysis changes once you have a bellwether case selected, or if you've got named representatives in like a Rule 23 class action case. But what I tend to do is I try to figure out what are the apps that the plaintiff has that they've been using that would have relevant information, right? So you go through your data mapping or your interview with your client. Hopefully they're remembering, you go through it a few times. And then for me, it's figuring out, okay, what can the plaintiff do on these apps to prevent the auto deletion, if there is auto deletion, and figuring that out, having our IT folks available to them to help them do that, making sure they understand they can't throw away or replace their phone or their laptop or whatever it may be. But it is quite challenging, and it's a constant reminder to preserve the information.
We have one question. We'll try to get it, and then we'll do a quick wrap up.
Sure. Just to kind of add on to that point that you were making, obviously good IG policy and excellent legal hold kind of lives in the same world as the reasonable person, right? More of a myth than a reality. How do you are you seeing a lot more sanctions with unsophisticated clients or individuals that you deal with? Is it, are they no longer, is that no longer an excuse in today's modern world?
I think the larger corporations and the more sophisticated kind of routine litigators, if you will, they're very much aware of these issues. When we started with eDiscovery, everyone was focused on, okay, what are our search terms and who are our custodians? Now everyone knows you also have to focus on your data sources. And you can have custodians, that's great, but it's not going to capture the full picture if you haven't looked at all of the relevant data sources. And so I think we're seeing it, at least I have been seeing it less from those sophisticated players. And where I think it's having a little bit more difficulty is with those smaller mom and pop shops. They have limited online experience, limited data stored electronically, but enough sufficient data stored electronically, or they've taken their paper files and tried to convert it to electronic. And I think that's where the lack of sophistication experience as to what exactly these issues are is starting to rear its head in sanctions issues in court.
All right, we have less than a minute left. And Kristen, as our go-to expert, I'd like to give you the final takeaway for the group. And for those that didn't know, Kristen's been on the practice side for many years. I got to work closely with her in different organizations. So anything to take away for the audience on this?
Oh, I've got a really important one. make sure you hire your own technical expert when you go to court for sanctions hearings. If you got a neutral one, she's probably not going to be friendly to either side.
So again, thank you for spending the last 50 minutes with us. I really appreciate all the work that the panelists did, all the audience interaction. Ready for another great session.